computer. Okay, so here we are in module number 7. Word of just a heads up. This chapter has nothing really in the realms of technical. This chapter is all about the structure of the US legal system, how it works, various laws that apply, and the amendments and how they work in our field. This is, as far as I can see, the one chapter that is very minimal in the realm of technical, but is all about that legal aspect that you need to be familiar with. I know. Okay, well, the structure of the US legal system. All cases are tried per the state and the federal laws. We have the jury, a group of people who are put under oath to hear arguments at a trial and render a verdict of guilty or not guilty. The plaintiff is the person who initiates the lawsuit and is responsible for the cost of litigation. The defendant is the person who defends himself in a lawsuit. The US legal system comes from common law that is based on case law and precedent, with laws derived from court decisions. Precedent is court decisions that are binding on future decisions in a particular jurisdiction. Therefore, these laws are derived not from legislation, but court decisions. Civil law is based on the Napoleonic Code, based on Roman law. Civil law is based on scholarly research, which becomes legal code and is enacted by a legislature without precedent. The 3 primary bodies of law exist in the US: constitutional law, statutory law, and regulatory. The constitutional, or federal, outlines relationships between 3 federal branches while protecting the rights of its citizens. Statutory is written law from legislature at national, state, or local levels. These are codified, or statutes that are organized by subject matter, and uncodified laws. Regulatory law governs the activities of government administrative agencies, such as tribunals, commissions, boards, responsible for making decisions that affect the environment, taxation, international trade, immigration, and so forth. Oops. In the US, this is the structure of the court system. The basic structure of federal, state, and local courts is the same. A defendant has the right to a fair trial, with the outcome determined by a jury of his peers. The role of the judge is to facilitate the trial process and ensure that the proceedings are in accordance with the law, along with ensuring that the proceedings are free from prejudice and the innocence of the defendant is presumed until proven otherwise. The burden of proof is always on the prosecution. You have the appeals courts. These courts enable its citizens to appeal a conviction, deciding whether to hear an appeal. They are not trials. A panel of judges render a decision whether a mistake occurred in a lower court. The federal court is one type, consisting of the district courts, circuit courts of appeal, and the Supreme Court. They don't have general jurisdiction. And then, of course, we have the Supreme Court. The appointment for life or unless removed by impeachment. The judiciary branch is the ultimate arbiter of the law, not Congress or the president. Article 2 of the Constitution outlines the jurisdiction of the Supreme Court and other federal courts. The federal appellate courts, there are 13 of them, one for each of the original states. 12 regional circuit courts, as well as the additional one in DC. Each of these is assigned a circuit justice from the Supreme Court. These courts can refer cases to the Supreme Court with 3 judges sitting in each of those courts. There are the district courts. There's 94 of them across the US. Every state has at least one. Most federal cases, the criminal and the civil, begin here. Kidnapping or intellectual property cases are some examples cases tried at this level. You have the state courts. These vary at each state. Local trial courts are located throughout the state and hear cases at lower levels. If the defendant is found guilty, they can appeal a conviction in a state appellate court. Those are the highest courts in the state judicial system, the appellates. They have discretion over which cases they hear and are often referred cases where there could be an error in determining the law. They are confined to a particular jurisdiction and asked to preside over contentious decisions like elections. There are also the intermediate appellate courts. These exist in 40 out of the 50 states, and they have various numbers and judges in each state. These are some trial courts of limited jurisdiction: the probate or the surrogate court, the family for things like child custody, visitation, so forth, traffic, like driving violations, juvenile, small claims, and municipal. In a courtroom, there are a series of steps that have to be done. Everything is very scientific. The pretrial and trial steps in a civil or a criminal case are the jury selection, oath and preliminary instructions, opening statements, testimony of witnesses, closing arguments, jury instructions, deliberations, verdict, and sentencing. The jury is outlined in the Sixth Amendment. The process that a jury is selected is there. Some cases may require the jurors to be sequestered or isolated to prevent external influences on the jury decisions. The opening statements. Again, the prosecution goes first since they have the burden of proof and must prove guilty. The defense doesn't have to prove anything. Under the Fifth Amendment, the defendant need not speak ever during the trial, but will have direct examination and cross-examinations during the trial. The jury will then deliberate and decide whether guilty or not. A hung jury will occur when the jury cannot come to a unanimous decision and a retrial must occur. This is not necessary in a civil trial. The jury can also decide financial issues in a civil trial. It's the responsibility of the judge to determine the sentence. Criminal charges are initiated by government prosecutors on behalf of the people. The defendant is indicted to stand trial and answer questions relating to serious crimes or provide information. A felony is a serious crime and generally carries a penalty of a year or more in prison. A misdemeanor is a less serious crime with sentence of less than a year. A deposition is a sworn witness testimony taken during the discovery phase or prior to the trial, and is generally not taken for criminal cases. Civil cases can be presented with them. A civil case is brought by an individual or an organization, referred as a plaintiff against the individual or an organization. Civil trials generally involve disputes over money. If successful, the plaintiff is awarded money by the jury. A civil trial identifies whether an entity failed to act reasonably and prudently under a certain set of circumstances, or what's called the preponderance of evidence. Now, constitutional law. The First Amendment. Though this was written long before digital communications, we rely on the Supreme Court and lower federal courts to interpret what protections a person posting insulting comments has, along with the rights of the victim. Can any opinion, no matter how disturbing, be posted on a blog. There is sometimes a difference between moral responsibility and constitutional law. The Fourth Amendment protects people, not places. One of the issues that arises with the Fourth Amendment is the expectation of privacy. A link clearly exists between unreasonable search and seizures and the expectation of privacy, but the Supreme Court has not always been clear about the linkage, which causes confusions, and case law is the best guide for litigators. For example, one gray area of expectation of privacy is the workplace. Do you have privacy at work or not? A few other terms that you'll see under this amendment used in our realm is the exclusionary rule. Evidence seized and examined without a warrant or in violation of individuals' rights will often be inadmissible as evidence in a court. The fruit of the poisonous tree, a metaphorical expression to describe evidence that was initially acquired illegally. All evidence subsequently gathered at every point from that initial search is inadmissible in court. Certiorari? I don't actually know how to pronounce that. It's an order made by a higher court that directs a lower court or tribunal to send it court documents related to a case for further review. And motion in limine, request by a lawyer to hold a hearing before a trial in an effort to suppress evidence. Now, this that I have in front of you is a search warrant. Arguably the most important part of the Constitution for forensics investigators. Law enforcement must obtain a search warrant, a court order issued by a judge or magistrate, authorizing law enforcement to search a person or place, as well as seize items or information within the parameters of the warrant, before a search can be carried out. Investigators must demonstrate probable cause or conditions under which law enforcement may obtain a warrant for a search or arrest when it is evident that a crime has been committed. Warrants are specific to a particular crime and criminal investigation, specific to a geographical location. For example, if a house borders 2 counties, 2 separate warrants are necessary to search the entire property. In one case, law enforcement was issued a warrant to search a house, but the suspect's computer was located in a shed in the back of the house, which was not in the warrant and thus not permitted to be seized. Not all searches require a search warrant. Since the USA Patriot Act, law enforcement has greater powers, extending warrantless searches when a person's life or safety may be in danger or exigent circumstances. The DOJ has provided guidelines for warrantless searches and seizure of computers. When appropriate consent is granted to a government agent, a warrant is not required. Consent can be granted when an individual waives his or her Fourth Amendment rights. The search is limited to the physical area of the individual's authority and to a specific criminal investigation. A warrantless search is also subject to the totality of circumstances. The individual granting consent must be of sound mind, an adult, and educated with a certain degree of intelligence. Sometimes law enforcement uses the knock and talk. I found this picture hilarious. Without sufficient evidence, or they cannot demonstrate probable cause to enter a residence to execute a search, law enforcement can go to the suspect's home and try to obtain the consent of the individual to gain entry into the home and conduct a consensual search. Plain view doctrine allows government agents to seize evidence without a warrant when the officer can clearly observe contraband. The officer must be lawfully present in an area protected by the Fourth Amendment. Evidence must be in plain view, and the officer must immediately identify the item as contraband without further intrusion. Search warrants never allow investigators to conduct a general search. A couple more terms that go with this is plain error. Appeals court identifies a major mistake made in court proceedings, even though no objection was made during the initial trial in which judgment was passed and a new trial was ordered. The rules of criminal procedure. These are protocols for how criminal proceedings in a federal court should be conducted. There is the search incident to lawful arrest, allows law enforcement to conduct a warrantless search after an arrest has been made. And standing, a suspect's right to object to a Fourth Amendment search. So here's a question. When does digital surveillance become a search? Stingrays are a generic name for a device that acts like a cell phone tower to locate criminal suspects, but can also locate people in disaster areas like earthquakes. A pen register is an electronic device that captures telephone numbers. These require law enforcement to show that only the information retrieved is likely to assist in an ongoing investigation. Pen registers are not searches. In Smith versus Maryland, the DOJ admitted it conducted a search but contended that there is no expectation of privacy when using a cell phone. The prosecution stated that a court order did allow investigators to capture real-time data from Verizon. Earlier today, I took just a quick search for a pen register to put in here, and I found this company who has all kinds of tools for law enforcement to do digital surveillance. So I just stuck it here in case you were interested. Hey, how about GPS tracking? GPS tracking devices are prevalent and widespread with their legality in the fore. For example, it is not illegal for law enforcement to attach a GPS tracker if the area doesn't pass the Dunn test for curtilage and enclosed intimate space. Here's a quote from one of the cases, U.S. versus Knotts. Monitoring signals on these devices does not invade any legitimate expectation of privacy on the respondent's part, and thus there was neither a search nor a seizure within contemplation of the Fourth Amendment. The surveillance amounted principally to following an automobile on public streets and highways. A person traveling in an automobile on public thoroughfares has no reasonable expectation of privacy in his movements. Here's another quote that I found interesting from U.S. versus McIver. The undercarriage is part of a car's exterior, and as such, is not afforded a reasonable expectation of privacy. Now, I found those to be interesting. So you're telling me that if my house has a fence and a gate and the fence is closed, then law enforcement cannot set foot on my property to stick a GPS on the undercarriage of the car because that fails the Dunn test for curtilage. But if I have a home and my driveway is open, law enforcement can walk up and stick a GPS under the car. That kind of blew my mind, actually. But yeah, that was that's interesting. You probably couldn't because you're not law enforcement. I don't know about private citizens doing that to cars. I don't know that. But interesting mindset. I didn't think about, I didn't realize that being on the road just means you don't expect privacy. You have no reasonable expectation of privacy in your movements when you are driving. It is totally legal to be followed by law enforcement. I don't know. Food for thought. Traffic stops. In the case of Riley versus California, which happened in 2014, the U.S. Supreme Court ruled that police require a warrant to search the cell phone of someone who is arrested. This was a landmark decision for law enforcement and forensic investigators because the cell phone can no longer be searched in a during an arrest. So if you get stopped by the cop, they can't ask for your phone and start searching through it. That requires a warrant. The Fifth Amendment protects the individual from self-incrimination. That's what it means when someone says, I plead the Fifth. A defendant is not compelled to testify at a trial and may plead the Fifth. An indictment is a charge delivered by a grand jury stating that the accused must stand trial. Investigators must be sure to have gathered all the necessary evidence before the case goes to trial. The Fifth Amendment can influence the outcome of computer forensics investigations. For example, forcing a defendant to supply a password is forcing the defendant to provide testimony because the defendant is conveying his knowledge, a known PIN or password, to access files with an incriminating device. Conversely, the suspect can be forced to use his finger to unlock a laptop or smartphone. Biometric access is not protected by the Constitution. So let me reiterate that. If you have a Touch ID, if you have Face ID, anything like that, law enforcement can legally force you to unlock that device. So I would go as far as saying, in a company, it should be fine to use biometrics to log in. But when it comes to personal devices, do not use biometrics. If you get caught and arrested and they want to open the thing, they can do so if you have things like Face ID and Touch ID and all that. Well, a YubiKey is a physical object. So I would think probably. I would think the answer is probably, just like if they arrest you, they can use the keys of your car to open the trunk. But see, that's where two-factor authentication comes in. Because even if they have the YubiKey, if you have a password, then they can't access that account or accounts. Now, I am no law expert in any stretch of the mind, but that makes sense. Now, some legislation. There is the Federal Wiretap Act. This law states that law enforcement is prohibited from using wiretap without a judge's permission. A wiretap has to be authorized by the Justice Department, signed off by a U.S. District Court or Court of Appeals judge, and valid for 30 days. Under this law, service carriers may on occasion monitor and intercept communications to combat fraud and theft of services. This law was amended in 1986 by the Electronic Communications Privacy Act to include transmissions from a computer. The Stored Communications Act says there are no Fourth Amendment protections when using an ISP or an email provider. Stored communications are defined as any temporary, intermediate storage of a wire or electronic communication incidental to the electronic transmission thereof, and any storage of such communication by an electronic communication service for purposes of backup protection of such communication. Applying SCA is problematic since law enforcement operating in one's jurisdiction is granted a search warrant, but a service provider is headquartered elsewhere, with the actual service in another location. Through rulings based on this law, there should be a diminished expectation of digital privacy in the workplace. FISA, the Foreign Intelligence Surveillance Act. It outlines procedures by which electronic surveillance may be carried out to protect the U.S. from international espionage. This act was amended by the USA Patriot Act to include terrorism, which may or may not be state-sponsored. The use of pen registers and tap and trace devices in foreign intelligence investigations is listed in this law. There's a lot of ISPs who don't allow their customers to run their own SMTP servers. Even cloud providers don't allow that. The Computer Fraud and Abuse Act. It invokes stiff penalties for those found guilty of unauthorized access to a network. Section 814 of the Patriot Act made several amendments, like increasing the maximum penalty to hackers who damage computers to 20 years in prison, include intent to damage a computer rather than type of damage, and new offense for damaging computers used in national security or criminal justice. There is a portion of the corporate espionage law in your lecture notes, along with a few others that are important in that realm. We have the Communications Assistance for Law Enforcement Act. Telecom companies are forced to redesign their infrastructure to meet compliance with this law. VoIP operators are not subject to this and might not be able to assist law enforcement with investigations since VoIP has no switches on a network and therefore provides serious technological challenges using a wiretap. Yes, this is why it is important that when you do a penetration test, you stay within scope, because of that law, you could go to prison for 20 years. The USA Patriot Act provides greater power to law enforcement to prevent terrorist attacks from reoccurring. Law enforcement can conduct surveillance without judicial approval in certain circumstances. This law has impacted digital forensics, for example. If law enforcement receives an email from someone who's been kidnapped, then they can act without the use of a warrant because someone's life is in danger. In the lecture notes, I have outlined a couple of the sections, like Section 202, the authority to intercept voice communications in computer hacking investigation. 209, voice messages, voicemails, are no longer protected by the Fourth Amendment. 210, subpoenas can include records of session times and durations, any temporarily assigned network addresses, obtain credit card bank information of internet users. It compels ISPs to provide complete details about incidents. 213 is called the sneak and peek warrant provision. Search a home or business hastily without notifying the target in advance. Prevents criminal suspects from tipping off other criminals about an imminent search. 216 extends pen registers and trap and trace statute to non-content information to the internet to include IP addresses, MAC addresses, port numbers, and user accounts. Section 217, an individual victim of unauthorized access by a hacker can allow law enforcement to intercept the communications of the trespasser. It has to meet 4 conditions. The owner or user of a protected computer must authorize the interception. The person who intercepts the communication must be lawfully engaged in the ongoing investigation. Reasonable grounds to believe that the interception of a communication will assist in the ongoing investigation. Investigators must only intercept the communication of the trespasser. Yes, if you have 911 texting and you say you need help, law enforcement can go in without the need of a warrant. Thanks to the USA Patriot Act. Protect. It provides greater protection for children against abuse. Eliminates waiting periods for law enforcement to begin investigation of missing people 18 to 21. Eliminates statutes for limitations for child abuse and kidnappings, and prohibits computer-generated child porn. The DCMA. There are 4 titles to it. Title 1 is the World Intellectual Property Organization. Title 2, the Online Copyright Infringement Liability Limitation Act. Title 3, Computer Maintenance Competition Assurance. And Title 4, has 6 miscellaneous ones that cover everything from ephemeral recordings, webcasting, bargaining agreements, and so on. Oh, there's also CLOUD, the Clarifying Lawful Overseas Use of Data Act. It obliges US-based tech corporations to allow federal law enforcement to obtain data stored on servers domestically and internationally with a subpoena or a warrant. Hasn't been ratified by countries like the EU yet. Expert witnesses. Actually, before that is the rules of evidence admissibility. Sorry, I jumped ahead. There are a couple of tests, like the Fry and the Daubert test. As you can see, the Fry is based on Fry versus US. Expert opinion must be derived from a thing and must be based on science that is demonstratable and not experimental. The Daubert test, based on another court of Daubert versus Merrill Dow Pharmaceuticals, computer forensics investigators must perform benchmark testing on their hardware and software tools. This testing will enable the investigator to explain known error rates. Now, expert witnesses. Testimony that is not firsthand is hearsay, unless it is digital evidence, allowing an expert witness to provide his opinion during a trial or deposition. Both defense and prosecution can use their own expert witnesses and cross-examine the opponent's expert. The goal of the defense is always to discredit the expert testimony, evidence, tools, and scientific methodology. There are federal rules of civil procedure that apply to civil cases with expert witnesses. They must provide a written report to the trial, disclose an important part of the discovery. Their reports must have all kinds of things like the facts, complete statements, witnesses' qualifications, all the stuff that we talked about earlier in another module. There's also the best evidence rule. The secondary evidence or a copy is inadmissible in court when the original exists. This rule is exempt for digital evidence. And then a quick look at the EU, China, and India. The legal system in Europe is based on the Roman law of people, property, and Roman law, people, property, and acquiring property. The EU has 27 countries in the dual legal system. Each country has its own laws, and then the EU law. Of course, for us, the big thing that we know the EU for is GDPR, which makes a distinction between personal and sensitive data, makes a distinction between data controller and data processor, also makes GDPR or makes investigations attorney directed. The incident responder may have to seek advice from a cyber legal attorney, country legal, and the company's data protection officer during the investigation, along with a series of questions that have to be answered. If a US company has an employee in Spain whose laptop was stolen, it would be problematic to check if the laptop was compliant, like say encrypted. The local and GDPR legislation impact whether the investigation must take place in the country, Spain, whether the data can be transferred back to the US, and permission sought from the employee to investigate a laptop owned by the company. China has the greatest restrictions on internet content, the Great Firewall, and the government closely monitors the contents of its citizens and what they view. India brought in a law in 2011, the Information Technology Rules of 2011, which protect the privacy of online consumers, and it's important to know that this legislation impacts US companies that outsource services to India. It has a couple of primary tenets: privacy policies, consent, consumer access and editing, transfer of personal data, and security. Hope that wasn't too terrible. Any other questions as I look at all three chats? I put a bunch of cases and more information in the lecture notes so you can continue digging further. You should have some knowledge of these things, but you're not expected to be, attorney level that you know it all. But it is an interesting topic.